Mr. Chair, I really hope that my colleagues support this amendment because I believe this is an unintended flaw in this bill that once I explain the policy behind the amendment and what it does, I think all members should be behind this. If you read Section 54, what it says is, it says if an accused fails to pay the amount set out in the ticket within the period set out in the ticket, the accused is liable for that amount, and a conviction is to be entered in the judicial record of the accused. The conviction is deemed to be pronounced by a court. They have 30 days after that day of the conviction to pay the amount set out in the ticket and the any court fees. 54.2 then says what the effect of payment or imprisonment is. It says if, after being convicted, the accused pays the amount set out in the ticket, or if the accused is an individual, the accused has served in full any period of imprisonment imposed as a result of a default in payment of the fine, the judicial record of the accused in relation to the offence must be kept separate and apart from other judicial records, and it must not be used for any purpose that would identify the accused as a person dealt with under this Act. And then finally, Section 55 says, only an individual who is unwilling, though able, to pay a fine or the amount of a victim's surcharge imposed in respect of a conviction may be imprisoned in default of its payment. So this is meant to avoid the stigma of a criminal conviction. So who doesn't get a criminal conviction? Someone who pays the fine, someone who doesn't pay the fine but serves the imprisonment, someone who could pay the fine but chooses not to, is not eligible for imprisonment. So the person that's left out of this is the poor, indigent person who just simply can't pay the fine. So if they just can't pay the fine because they're poor, then they end up getting a criminal record, and that criminal record can be referred to. So we heard a couple of pieces of testimony by Michael Spratt pointed this out. Michael Spratt said, to its credit, Bill C-45 does attempt to reduce the prejudicial impacts of this ticketing option, and there are provisions designed to prevent the public disclosure of judicial records. But that is dependent on the offender's ability to pay a fine. If a ticket remains unpaid 30 days after a conviction is registered, there is no corresponding right to privacy in a judicial record. If you're poor and you can't pay the fine, you get the record and you don't get the protection of this provision. He goes on to say, I think the problem is obvious. If you're poor and can't pay a fine, you are further stigmatized through a public record. If you are well off and can pay a fine, your record is sealed. The judicial record is non-disclosable. Given the research on the impacts of the disclosure of judicial records, the inability of the poor to purchase privacy rights, and the disproportionate enforcement of marijuana offences experienced by marginalized groups, it's quite likely that this ticketing provision will be found to violate the Canadian Charter of Rights and Freedoms. Now, Ms. Sidhu clarified this with him. She asked Mr. Spratt, for clarification, Mr. Spratt, you said that people who are unable to pay tickets are criminalized. In fact, Clause 55 states that the ability to pay is a clear consideration in ticketable offences. If you cannot pay, you won't be further punished. I wanted clarification on this. Mr. Spratt responded, it's not that you'll be jailed. The Act is clear that the judicial record won't have the same privacy protection as it does for someone who can pay. The punishment I speak of isn't incarceration. Rather, it's the devastating impacts which are well documented of the disclosure of judicial records. That's how they're punished. So I think this was an unintended gap in the bill where that my amendment clears up. So what my amendment would say is this. It would add a new 54.1 that says this. If an accused establishes to the satisfaction of a court that payment of the amount set out in a ticket or of a fine imposed under this Act would cause undue hardship to the accused, the court may, on application of the accused, make an order exempting the accused from the payment of the amount set out in the ticket or that of the fine or both. For the purposes of subsection 1, undue hardship means the accused is unable to pay the amount set out in the ticket or the amount of a fine imposed under this Act because of the accused's precarious financial circumstances, including because of their unemployment, homelessness, lack of assets, or significant financial obligations towards their dependents. And then finally, if the accused is convicted of the offence and a court makes an order under subsection 1, the judicial record of the accused in relation to the offence must be kept separate and apart from other judicial records, and it must not be used for any purpose that would identify the accused as a person dealt with under this Act. So in short, Mr. Chair and colleagues, what this does is this says if a person can satisfy court that they're poor and cannot pay the ticket, that their record will also be treated in the same way as someone who has paid the fine or the ticket. So you don't leave the poor with the stigmatization of a conviction that's not separated as it is for those that can pay.
Thanks very much. Ms. Gladue.
And I want to thank my colleague for bringing this one forward. Certainly, I agree with the principles that he's talking about, that, you know, if you're poor, you shouldn't be punished for not being able to pay your ticket by receiving more criminality or less privacy or anything else. So in principle, I agree, but I'm concerned because the response to my question about what kind of database they're going to use to keep these things in, what detail level are they going to do to administer that, that has not even been thought of. And 271 days from now, it'll matter. So I won't be supporting.
Mr. McKinnon.
I'd like to respond to my colleague. I think the intent is well-meaning. I think it is, you know, it's a good intent. However, the criminal code provisions already grant the court discretion such that if it is satisfied that the accused cannot pay a fine, it has other options available to it. They also have the ability to grant an absolute discharge or conditional discharge to an accused who they believe cannot pay the fine, or to allow them to discharge a fine by earning credits for work performed. And this motion, or this was also further clarified with our previous Liberal motion 8, which clarified the court's ability to impose a fine that is up to $200. So I believe that this amendment is unnecessary, and it is covered by the existing bill.
Mr. Davies.
Well, if that were the case, then I would agree with my colleague. But I believe that he's not reading Section 54.2 properly. 54.2 says the effect of payment or imprisonment. It says if, after being convicted, the accused pays the amount set out in the ticket. Then it goes on to say that the judicial record of the accused in relation to the offence must be kept separate and apart from the judicial records. So what I'm talking about is after conviction. So let's say you have a wealthy person who is convicted, and you have an indigent person who is convicted. The wealthy person goes and pays the fine, and their judicial record is now kept separate and apart from other judicial records, and it can't be used for any purpose that would identify the accused as a person dealt with under this Act. But at that point, the indigent person can't pay the fine. And this is after conviction, so there's no possibility of a discharge at that point. They've already been convicted. And that's why this amendment is so important to deal with that situation. And ironically, the person 55, when it says it would leave that person then with the only option, which is to serve the jail sentence. So they serve the jail sentence, and then they can be treated the same way. So really what we have here is we have two different standards of justice. Your criminal record and your privacy expectations are dependent upon your ability to pay, and surely that can't be the intention and desire of the Liberal government.
Mr. McKinnon.
Chair, I wonder if our officials could clarify this question, the matter of having, once being convicted, being able to, have a conditional discharge, if that is part of that. It seems to me a discharge is part of the sentencing. And the other aspects of Mr. Davies' concern.
If I could spoke, and there's another consideration I wanted to add to that question, if I could. Thank you. I was trying to understand this at the time I read it, and I think I understand it now. Here's the other, I think, confusing rub. Section 55 says only an individual who is unwilling, though able to pay a fine, or the amount of the victim surcharge in respect of a conviction referred to in subsection 53(1), or a fine imposed in respect of a conviction referred to in section 54, may be imprisoned in default of its payment. So here's the irony now. I think I'm reading this properly. A person who can't pay the fine because of they're impoverished can't even serve the sentence, because this section says the only people who can be imprisoned for default of payment are those that are able to pay but won't. So an indigent person can't pay the fine, so they can't get the benefit of the record, I'll call it record sealing for lack of a better word, and they can't serve the jail sentence because they're unable, only people who are able to pay are able to be imprisoned. So you have an indigent person who has no way of actually having their criminal record treated the same way as someone who can afford to pay, or ironically, someone who can afford to pay but won't. That can't be the intention of legislation or Parliament.
Thank you, Mr. Chairman. The courts have a wide discretion in terms of sentencing options. With respect to fines, it was pointed out that the court can impose a fine of up to $200 now as a result of the motion that was adopted by this committee. The courts already have discretion in terms of alternatives to imposing a fine. In the case of an indigent person, there's an obligation under the code presently for the courts not to impose a fine if the court is of the view that the person cannot pay the fine. Alternatively, in those cases, the court could impose a fine option, or rather sentence the individual to serve a period of time in a fine option program where he would do work in the community. So the indigent person is not going to be compelled to pay a fine that the court knows cannot be paid.
Okay. Mr. Davies?
I just ask a question of that. I mean, Mr. Senti, so you're saying in Canada today that it's never the case that an indigent person receives a fine in a Canadian court? Can you speak with that kind of certainty?
No, I can't. I'm just pointing out what the criminal code provisions set out. But I'm not aware of indigent persons being jailed for not being able to pay a fine.
No, that's not.
Perhaps my colleague can add to
Sure.
that.
So to the point about C-45 reflects what the Supreme Court has said, which is if a person is unable to pay a fine, they cannot be imprisoned for their inability to pay through no fault of their own. As my colleague has said, if an individual does not, so the starting point is the court has to first determine, is there an ability to pay a fine before the court can impose a fine? And then the court must determine what is the amount of the fine. C-45 provides a maximum limit on that. And then alternatively, if there is, once the fine is imposed at whatever the limit, the amount is, if there is a fine option program in the province, it is possible for an individual to work towards discharging that fine through the work credit. But I think one of the things that perhaps is causing a bit of confusion is between the first part of the ticket process is an individual that is issued a ticket chooses to pay or to challenge the ticket. But then the second part of the process, which I think Mr. Davies was dealing with, is if the individual challenges the ticket and goes through a court process, the court then makes determinations as to whether or not an offense has been committed, and if so, what is the penalty to be imposed in that situation. The individual is acquitted, there's no need to protect the record. If there is a conviction entered, then the provision at Clause 54 protects once it's paid, or how it's dealt with in accordance with that individual and whatever the court imposes for the fine, then that part is protected as well in terms of the record, the judicial record of conviction.
Appreciate that. Mr. Davies?
Yeah, it's a confusing section of the code, but if someone, a police officer gives someone a ticket, he gives an indigent person a ticket. If the person, now, we're making a lot of assumptions here. We're making an assumption, I'm assuming that the person doesn't pay the ticket because they're poor. May not even show up in court. Section 54 says, if an accused fails to pay the amount set in the ticket within the period set out in the ticket, the accused is liable for that amount and a conviction is to be entered in the judicial record of the accused. So an indigent person who doesn't show up in court for the ticket, this happens every day. Canadians don't go to court when they get tickets. A conviction's entered. And then once that conviction is entered, the 54D says the accused has 30 days after the day of the conviction to pay the amount set out on the ticket. If they don't do that, then section 54.2 says if after being convicted the accused pays the amount, then it goes into the fact that their records kept separate and apart. So I still say that the scheme of this section leaves open the very real possibility that indigent Canadians, unless they go to court, and in many cases they will not hire a lawyer. They may not even be able to represent themselves very properly. They may not even know to say that they can't afford the fine. It leaves open the possibility there's a structural flaw here in the bill where the way that your record is treated is all depending on your ability to pay the fine. And I'm not saying that people go to jail for not paying fines. I'm saying that every day in this country, indigent people get ticketed and they get a fine of some type and they don't pay it. And I just don't think that it's fair or right that we treat the way their criminal record is treated is protected by whether or not they pay a fine. And so the effect of my amendment, I think, would only bolster that. I don't think it changes anything. It just clearly directs a judge in terms of an offense under this act that if there is undue hardship and the person can't pay, and again, there's this odd, I think, anomaly of saying a person can't even serve the time, if they can't pay. It at least says that an indigent person, if they satisfy the court of that their inability to pay the fine is not a reason to have their record treated separately, which is exactly what it says now. So.
Thank you very much, Mr. Davies, and we understand what you're driving at. But I see no further speakers, so I'm going to call for a vote on NDP 29.
A recorded vote, Mr. Chair.
Certainly. Recorded vote.
Monsieur Ayou, Mr. Yolson, Mr. McKinnon, Mr. Oliver, Ms. Sidhu, Ms. Gladue,
No.
Mr. Van Kesseren,
No.
Mr. Weber, Mr. Davies.
Yes.
Yes pour 1-1, les contre 8-8.
I declare NDP 29 defeated.